Procedural background. The defendant was convicted by a jury of first-degree murder, and of course, this is Maryland, so a variety of handgun offenses. The appellate court of Maryland reversed the judgment, remanded the case for a new trial on grounds that are not relevant today. On remand, the defendant filed a motion in limine to exclude firearms identification evidence. The state intended to offer through its expert witness, Scott McVeigh, a senior firearms examiner with the Firearms Examination Unit of the local police department, doesn't really matter. The trial court held a 4-day Fry-Reed hearing, during which both parties introduced evidence and elicited testimony that we summarize. So a Fry hearing, folks, is a form of hearing where the qualifications and the relevance of the expected testimony of an expert witness can be vetted. The parties can argue whether the person is in fact qualified and whether or not what they're going to speak about is actually relevant to the facts of the case. There's every jurisdiction has these in America. Fry is one legal standard. The more common legal standard now is Daubert from the U.S. Supreme Court. And here in Colorado, they call it a Shrek hearing. When I testified as an expert witness a couple weeks ago, I had to, a few days before my testimony, participate in a Shrek hearing where my qualifications were vetted to the court, direct examination by the defense because I was their witness, and cross-examination by the state.
Now, they later do get to a Daubert analysis, and it's interesting because Maryland looks like they're moving from Fry to Daubert, and there's some procedural questions about that. So they actually apply a Daubert analysis. And also in here, they actually add to it, which is fascinating. There is some additional, Daubert generally has a 5-point analysis. They add another, I think, 4 points in their analysis in here, which I had not been familiar with here in Florida. They add 6 through 10 points. If you look on admissibility of expert testimony about the additional points, they call it Fry Roachkin factors or Rockkind factors, which are Federal Rules of Evidence 702. Advisory committee note cleaned up for factors 6 through 10. Anyway, I'm skipping ahead. I just want to let people know that this is a Daubert decision now because of the change in law in Maryland.
And the reason we have all these rules, folks, for this evidence is because it's so easy for purportedly scientific evidence to outweigh everything else that's happening in the trial, because it's, especially if it's presented in an absolute sense, and we don't want bad science, fake science, putting people in prison for the rest of their lives. So the courts have always struggled with this, and that's why we have these different kinds of hearings, and that's why the standard changes over time, and that's why some states add even more check boxes that have to be cleared before the expert can be permitted to testify. Let's see. And of course, an in limine hearing is just a hearing where one party's asking that evidence not be permitted in front of the jury, and then they get to argue about that. Following the hearing, the trial court largely denied, but partially granted, the motion to exclude evidence. The court concluded that firearm and tool mark identification is still generally accepted and sufficiently reliable under the Fry standard, and therefore should not be excluded in its entirety. Nonetheless, the court agreed with the defendant that the subjective nature of matching analysis made it inappropriate for an expert to testify to any level of practical certainty, impossibility, ballistic certainty, or scientific certainty that a suspect weapon matches certain bullet or casing striations. The court thus restricted the expert to opining whether the bullet and bullet fragment recovered from the murder scene fall into any one of a particular set of 5 classifications, one of which is identification of the unknown bullet as a match to a known bullet. At trial, McVeigh, the firearms examiner, testified about the process by which he eliminated the Glock pistol as a source of the unknown crime scene samples, created known samples from the Taurus revolver, and compared the microscopic patterns and markings on the 2 sets of samples. Over defense objection, McVeigh opined that 4 bullets and 1 bullet fragment recovered from the scene at some point, this is a quote now, at some point had been fired from the Taurus revolver, period. So an absolute match of a bullet from the scene to the suspect Taurus 38 revolver.
And I'll tell you, that's pretty decisive evidence. You think about it, if a scientist comes in and says the bullet found in the body of the decedent was fired from the defendant's revolver, I mean, that eliminates a lot of doubt, right?
Yeah. What would be the hypothesis alternative to guilt?
Right.
There?
That's a hard hurdle to overcome. How does a defense ever overcome that type of testimony? It sounds like the case is solved, right?
Now, of course, there are gross characteristics of firearms that do allow elimination of a firearm as having fired a bullet. The caliber can be different. The number of lands and grooves in the rifling could be different.
Right.
I think Glock still uses a weird kind of, they call it polygonal rifling in their barrels. So the marks they leave are very distinct from a traditional rifled pistol. Right. So there are things where you can say, well, this gun could not have fired this bullet, or this gun might have fired this bullet. That would be reasonable on gross characteristics. The real trouble is when they get into this little microscopic comparison of these little tiny striations, and they're rotating the bullets under this dual eye microscope and say, nope, this is exactly a match. The bullet I fired as the examiner through this revolver exactly matches the bullet I found at the scene. So it had to be the same gun. Mr. Abukwa, he was remanded for retrial. Remember, he was again convicted of first-degree murder and use of a handgun to commit a crime. His first appeal from that conviction resulted in a remand to the trial court to consider whether it would reach a different conclusion concerning the admission of the firearm and tool identification testimony, applying a then new standard. So Maryland had developed, between the first trial and the second trial, they developed a new legal standard for this kind of evidence. And they wanted the trial court to assess whether or not, if they applied the new standard, would they get a different result on admissibility. In that decision, which was issued after his second conviction, while appeal was pending, we abandoned the Frye-Reed standard for admissibility of expert testimony in favor of the standard set forth in Daubert, U.S. Supreme Court decision, Daubert v. Merrill Dow Pharmaceuticals, and its progeny cases. So essentially, Maryland went from Frye standard to Daubert standard, and then I guess they layered on a few more checkboxes of their own on top of Daubert. On remand, the trial court held a hearing in which it once again reviewed evidence from both sides. The court ultimately issued an opinion in which it reviewed each of the 10 factors this court has set forth in evaluating expert witness testimony and concluded that the testimony remained admissible. The trial court noted that although the defendant had made a Herculean effort to demonstrate why the evidence should be heavily scrutinized, questioned, and potentially impeached, the state has met the burden for admissibility of this evidence. The court therefore sustained the defendant's prior conviction. The defendant filed another appeal to the intermediate appellate court. That would be between the trial court and the Supreme Court. And while that appeal was pending, he filed a petition for writ of certiorari in this court. We granted that petition to address whether the firearms identification methodology employed by firearms examiner McVeigh is sufficiently reliable to allow a firearms examiner without any qualification to identify a specific firearm as the source of a questioned bullet or cartridge case found at a crime scene. So that's the specific question, folks. Is firearms examination sufficiently robust, reliable as a science to allow an examiner to testify to the jury that he can absolutely match this bullet found at the scene to this particular firearm?